Good morning, everyone, and welcome. I see we're quite a bunch of people, and we're still waiting for quite a few more people to join us. There is a few of you guys that are going to have load shedding, so we are recording this session. We normally don't have a problem with it, and then we will upload it to the Training Academy afterwards. But please do stay for the entire session. It's going to be absolutely amazing. So let's get straight into why we are here. So today we have three amazing people from Bruno and Simão attorneys. And when I say that this is an absolute privilege to have them here, these people are all things investments, all things rentals, all things leases, you name it. They are probably the best of the best in South Africa. So their specialities include investments, structures, tax, funding, dispute resolutions, commercial, eviction, leases. So you guys can see what a powerful team this is. So we have three amazing speakers today. First is Bruno. Bruno, give us a wave over there. He's gonna start you guys off. Then we're gonna have Alexa. Alexa's there we go, and then you are going to be meeting Leonora. She is online. She'll probably open up her camera as she comes on for the session. So guys, we're going to have all the questions at the end, but as you have them, put them in the chat box. When it's question and answer time, we'll just go back to the questions and then answer them for you guys as well. So this is going to be a jam-packed session. It is going to be around an hour and a half, maybe 2 hours, but mostly an hour and a half. So please do stay present for the entire session because you do not want to miss a thing of this session. So let's not waste any time. Bruno, the floor is yours.
Wow, Nicolene, those are incredibly kind words. I actually really hope I can live up to that. But good morning, everyone, and thank you for joining us. The turnout's incredible, so I'm really happy to see so many people in the room. And yeah, I really hope that I can give value today. I'd love feedback. I want questions. Let's see if we can engage a little bit. But yeah, I'm super excited. Thank you so much for having me. Before I start these talks, I normally like to express the outcome, what I'd like to see agents or the people that I'm training getting out of this. And one of the primary features in this type of environment is twofold. It's obviously the training component of it, but there's also the solutions component of it. And I find that very crucial because we can give a lot of training, but a lot of the times we need to actually implement these solutions, write them down, get them to a point where the implementation is actually possible. So the idea of today is to introduce a number of different topics, a number of different problems, concerns, contentions, and start having conversations around it. Start discovering that options do exist. How do we get to those options so that we can actually sit down at a point, create a flow that works for everyone, and then be able to train everyone on it. So the conversation today is going to be broad, but it is going to be jam-packed. We are going to get through a lot of it, and I do want the engagement towards the end. But before I get too ahead, let me just introduce the team. Although I'm not going to lie to you, Nicolene's introduction is probably a lot better than mine, so I should leave it at that. So let me just say that I'm Bruno, and I'm the founding attorney of BSA Law. Leonora Swart is my head conveyancer. So I've known Leonora for many, many, many years. She's one of the best conveyancers that I've ever worked with. So she deals with the conveyancing side of things. And Alexa Levendal, she's also been with me for many, many years. She's one of my associates. Very proud of her. She does great work in the eviction space and the litigation space. And the three of us today are going to basically guide you through leasing. And what's interesting about today, and I think I need to mention this before we start, is a lot of people look at leasing solely in the leasing space. So as a letting agent, I need to understand how lease agreements work, how the Rental Housing Act works, whatever it is. But very few times we actually pay attention to sales agents, for example, within the leasing space, because when you sell property, sometimes there are tenants. So the merge or the overlap of these two considerations is actually crucial for both sales agents and letting agents, because we've seen a lot of problems develop when properties get sold, but the tenants aren't properly being dealt with by the sales agents. And that's what we're trying to mitigate here. And so we've designed the content in a way that the beginning is just an introduction to try and get people around the idea of leasing and what it entails. And then I'll go through the agenda in a second, but basically Leonora is going to come in and try and assist sales agents with leasing concepts. And then we're going to go into a bit more legal detail on the certain solutions that both sales agents and letting agents should probably have in their arsenal when they're engaging with people. I normally, so again, Nicolene actually did the credibility element for me, but I normally just do this because obviously for those that don't know me, I've worked with a number of you, but for those that don't know me, I have worked with a variety of different estate agencies under my own brand, under Property Law Alliance, which is an alliance of 3 different firms of attorneys that focus on bringing legal solutions to the property space. And you'll see from some of the logos there, some of the guys that we've been doing training with, some of the guys that we support. So that's just for the sake of credibility. So if you ever ask yourself, but does Bruno know what he's actually saying? I certainly like to think so. So the agenda for today, just so you guys can prep yourselves and you know more or less where we stand at any given point in time. I'm going to briefly do an introduction leading up to a mindset and certain basics on leasing. Again, this is very good for both sales and letting agents. Leonora is going to jump in approximately at 10:30. I don't know how strict we're going to be able to be with that. She's going to jump in and she's going to discuss the sales component, especially when it comes to leasing. Then Alexa and myself on part 3 at around 11, we're going to be discussing some legal solutions. Why that's crucial and why I think everyone does need to stay for part 3 is, remember, the first one just teaches you what's out there. The second one points out certain problems that that sales agents especially are going to experience. The third one is going to give you the tools so that you're actually able to tell the seller, tell the lessor, the landlord, actually be able to impart knowledge, give them some guidance, give them comfort, support, because you actually understand the process. So this isn't training to be a lawyer. We're not expecting you to, be able to draft an eviction when we're done with this. But at the very least, if you understand and you're able to convey this to the client, you're better able to manage their expectations. And that kind of leads me straight into then part 1 of the session, where we're just going to quickly discuss the mindset. Now, the reason I do this first is a lot of attorneys give training and they go straight into the legal, like, okay, great, let's start lease agreements. This is what it looks like. And that's fine. There's nothing wrong with that if it's a legal seminar, which, I mean, in fairness, this is. But the problem that I experience personally is a lot of the issues that arise and that land up on my desk or before Alexa's desk is the fact that the situation wasn't actually managed. And this is crucial. And I mean, a lot of the senior agents out there today are going to understand this. So they're probably rolling their eyes at me going, yeah, but we know this. But it's still crucial to remember this. And through storytelling, through experiences, I believe that it's something that needs to get repeated. Why? Because a lot can be avoided. So you'll see over here that what I specifically mention is we had to manage the person, not the property. Now, that sounds weird. And I mean, as property practitioners, we go out there and we're like, we know property, we love property, we know our areas, we know the pricing. But think about it, at the end of the day, you're selling property to people, right? Property is just what you're doing, but you're actually selling it you're managing people. So you're either selling it to people or you're leasing property to tenants. But the bottom line is you're handling or managing people. And a lot of the evictions or rental issues, especially with tenants and landlords, arise because the management isn't done the way that it maybe should. And this could actually spare you a lot of issues because number one, you want to keep the landlord. Remember, the landlord that comes to you, especially from a leasing perspective, is supposed to be repeat business. From a sales perspective, yes, a person buys their house, maybe they don't want to buy again. So you do the job to get the purchaser his house, and maybe that's it. Seller sells one, purchaser buys one. You might not see those guys again. But with leasing, once the relationship begins, more likely than not, that landlord would want to keep that investment property with you. But on what grounds? Predominantly if it continues to be an investment property. And how will it continue to be an investment property? If it's making money and if it's not giving him a headache. And the agent's function is to retain this business by making sure the landlord experiences as little pain as possible. And that's a business strategy. We do that for our clients. We take on the burden. It's almost like a sin eater. We take on the burden so that the clients don't have to experience it. And we train ourselves to be able to deal with it. And it's exactly the same with property practitioners, estate agents. So expectation management is the first key concept here. Expectation management is knowing what to tell the client so that you don't undersell something or oversell something. The eviction process is going to take X amount of time. The clients need to know this. The most disappointment I get in practice, especially in litigation, because remember, litigation is often a grudge purchase. No one wants to pay a litigation attorney to go sort out a mess. You'd rather not have the mess to begin with. But if they are going to approach you, the best thing that you can do for yourself is make sure that they understand it might not always be a pleasant experience. It might take a couple of months. The cost associated with it is X, but we will try our best. Because at the end of that, if you do it faster, if it costs less, the client will actually be satisfied and happy with the job that you've completed, as opposed to realizing that they've paid double and it's taken years as opposed to months. So expectation management, you need to know what the process are and how to resolve it. But most importantly, you need to have that relationship with the landlord so that they understand it. Worst thing I've seen is landlord doesn't understand what's coming next. They make assumptions that things like evictions, for example, can be done tomorrow. Lock the door. Great. Yeah, it can be done tomorrow. They start making these assumptions only to realize they're not true. And what does that create? Disappointment. Rather do the disappointment at the beginning when you tell them how it works, then continuously have to keep disappointing them over a period of time. So this is just business dynamics. Mindset of managing occupiers. Another big problem that we see is by the time an eviction comes to us or rental collection comes to us, especially evictions, because rental tenants don't tend to want to stay on the property and fight an eviction unless the circumstances are very, very dire. But the ones we find that will do it is to prove a point. It's the ones where they're angry with the landlord because the landlord said something to them, or the landlord tried to do something, or their estate agent tried to do something, or their estate agent told them something that they believed, and now they're relying on it. So it's very important to change your mindset so that you actually manage the occupier. You make sure that any problems that arise that you're able to deal with. So we do, for example, a lot of inner city evictions. We do student accommodation evictions. We do suburban evictions. And each one of these tenants is different. And that's why as an estate agent, you guys need to know your market. You need to know who you're dealing with and how to deal with them. Some people expect engagement. Some people take offense if, they get a very upset email or a very upset SMS if something went wrong and they didn't pay rent. Now, this isn't to say that you shouldn't follow legal process, but it's also about creating steps so that you understand where the tenant sits and that you're actually able to manage them. You want them to prioritize the payment of rent as number one. And the way that they do that is by feeling obligated to do it. As soon as they feel that they're not being taken care of, all of a sudden that priority on rental payments starts going down. You want to make sure that if they need to move out, that they realize they need to move out, that there isn't animosity on their part. And this normally requires proper tenant management and tenant engagement. And all of this kind of wraps up to say, lawyers as last resort, absolutely. By the time it hits a lawyer's desk, the situations become dire where you need a third party to come in and try and resolve this. One of our biggest plus sides or advantages is even when clients come to us, we still try to resolve and manage the situation because we find that most of our evictions can actually get sorted out within the first couple of steps in the eviction process because we try to resolve it. We try to persuade people that it's in their best interest to move out this property. So in your mindset as a property practitioner, use your lawyers to support you. So use us as solution practitioners that come up and assist you with how to implement processes. But as litigation practitioners, that should actually be the last place that you'd want it to go. Because again, your client, the landlord, is going to be very, very upset, and he's going to have a bitter taste in his mouth if he continuously has to pay for a grudge purchase which he doesn't like. So you want to try and manage it before it comes to us. But fortunately, when it comes to us, some firms like us do tend to focus on the management component as well. So we support you when it comes to that. So that deals with the first part of it, which is the mindset part. Now, shifting from the mindset to some of the legal basics, the one thing that's crucial for everyone to remember is I'm not going to spend time on vetting. I'm not going to spend time on the need for a lease agreement. I'll speak about lease agreements, but not the need for a lease agreement and the legal flow and solutions process, obviously, that we're going to be discussing. Now, you guys know that vetting is crucial. I mean, it's the biggest thing. I mean, it's why the procurement process from a letting agent side, even if it's just tenant procurement and not management, I mean, you need to understand how bad tenants can be, and you need to communicate to the landlord that the higher the rent he wants, more than likely he's going to get fewer to choose from, and he might have to settle for tenants that aren't incredibly reliable or consistent. But it is crucial, obviously. Written lease agreements, I don't need to tell you guys this as well. I mean, as rental agents, you know, the agreement needing to be in writing is very important. It's not that it's not a lease if it's not in writing. It's still a lease if it's verbal. But no one knows what's happening with that lease and causes delays. So making sure that everything's in writing, any potential changes and variations, anything that changes in the lease agreement be properly documented. Because we've seen lease agreements 5-6 years down the line where people don't know what's happening with them. We don't know what the time periods are. You start making assumptions, what the obligations are. It does create problems. So obviously, as letting agents, you want to be able to manage that process and make sure everything's documented. And then the legal flow and solutions process, that's what we want to do for you after today. We want you guys to pick up certain red flags and actually approach us and engage us to see if there's any solutions that we can do for any specific problems that you guys are having, or more training. Maybe it is just a matter of breaking down these topics into a little bit more detail and spending more time on each. All right, it's now 20 past, so I'll probably spend another 15 minutes. So 5 minutes, 5 to 8 minutes over the half past mark. So lease agreements as a basic, the basic definition is it's a contract for the temporary use and enjoyment of property, right? So the property is being temporarily used by one person, the tenant, and the tenant in exchange for this is paying rent. So that's a very basic legal definition of this. It can be in writing, it can be verbal, it can be tacit. By tacit, I mean, even though certain terms weren't agreed to by a person's conduct, it's implied that there's a lease agreement in place. And you very often find this, for example, in a combination of where there's where there was a lease agreement was emailed between the parties, but no one actually bothered to sign it. So technically, there's no written agreement, but a deposit's been paid, rent's been paid, the person's moved in, the landlord's given keys, and in those instances, it's still a tacit lease agreement. So that's very, very important to remember for everyone. Lease agreement need not be in writing. If the person moves in based even on a lease agreement that wasn't signed, you can assume that that lease agreement is now applicable, and the general rules for cancellation and eviction and all of that kick in. Then the lease agreements in South Africa, the most important pieces of legislation, especially when it comes to shorter term lease agreements. And when I say shorter, I mean not the long-term 10-year lease agreements, because we've got specific legislation for how those ones are supposed to be governed. But 1-year lease agreements, 6-month lease agreements, so not Airbnb sort of thing, subject to the Rental Housing Act, Consumer Protection Act, the Property Practitioners Act, which has just now come into play, and then obviously the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act, and that's quite a mouthful of a name, so we just call it PIE. So these are the applicable piece of legislation. So what I'll do very briefly now is I'll just touch on some of the crucial points in these pieces of legislation that always merit consideration, it always merits knowing what these say, and these are the sort of things that we might need to break down into further detail the next time we do one of these sessions. So the first one is the Rental Housing Act, Unfair Practice Regulations. So I believe that this is actually crucial. This particular act and these particular regulations are actually crucial for all estate agents, and they do form a basis of the training, especially if it's just leasing. It's a question of going through this. It's not a long act. You read through the entire act, you understand the act, you understand the regulations. It's very well written, so it's actually quite easy to read through. It shouldn't take more than an hour or two to go through it. I would suggest, as a homework assignment, as it were, that everyone maybe make the effort to read through this, especially as a leasing agent, because everything in this act is applicable. Things, for example, that I've seen applying is obviously the leases not necessarily needing to be in writing, but if the tenant wants to, they can ask for the lease to be in writing. Unsigned or undelivered lease agreements, this act actually provides for the fact that if somebody moves in and the agreement hasn't been signed, but there's been acts on both parties, almost acceding to the fact that a lease exists, that the lease is deemed to exist in terms of the act. Things like rentals, for example, rental escalations, there's specific notice that needs to be given on rental escalations. So despite what the agreement says, the act does require that you give a person 2 months notice if you expect to escalate the rent. And obviously rental receipts. So the act is very big on rental receipts. The reason for this is a lot of disputes normally arise because especially with cash payments. So rental receipt, when there's an EFT, almost seems superfluous, but with cash payments, you tend to find that the rental receipts are actually quite crucial. Yeah, rental receipts is definitely something, and you have to do it. So in terms of the act, it's a must. The conditions, obligations, and maintenance. So the act provides quite a lot regarding each party's obligations to each other. Now, what's very interesting here, and I suppose this is a criticism I've always had on the regulations or the act itself, is it's drafted very well to say, well, the tenant has to pay the rent he's supposed to pay. The tenant has to keep the property in a great condition. The tenant has to leave when you ask him to leave and it's validly cancelled. It provides for all these obligations for the tenant, but the problem with the tenant is, in order to actually enforce these obligations, it lands up being quite daunting. So the act is great, and I mean, if a landlord would read this, he'll be so happy with all the rights that he perceives himself to have. The reality behind is the enforcement of these rights, as you guys know very well, is not necessarily easy. So even though the act says the tenant needs to vacate, it also says that the landlord cannot kick the tenant out without a court order. So all in all, it's pretty much just codifying what we all know, that evictions have to be by way of court order. The act is just being very nice on how it speaks about this. And it does make certain contraventions of the act an offense, criminal offense. But honestly, I've never seen a tenant be prosecuted for that sort of offense. I've only seen landlords get prosecuted specifically when it comes to their obligations, but with the more serious obligations, for example, elevator safety and health and safety in big buildings in the CBD. That's kind of a big one. So there, I have seen prosecutions because people might have actually died or gotten sick from it. So that's just something on those bigger buildings that might actually fetch the wrath of the law. And then entry, obviously entry is a crucial one. You guys need to be able to get into the property. Sales agents need to be able to showcase the property. Leasing agents need to be able to inspect the property. Access is an entitlement in terms of the Act. Acquiring access, interestingly enough, and not a lot of agents know this, we don't necessarily always need to evict in order to acquire access. It's actually a very basic application that we do. In fact, if I'm not mistaken, we created the first of these applications many, many years ago when a person bought a property and they just wanted to inspect the property and access it. And these were the access applications where you go to court and you basically say, look, I don't plan to infringe their rights too much. I just need access because I need to verify the property. I need to inspect it. I need to make sure that the condition of the property is good. I mean, we've even got an access orders. We've had to put security guards on the property for fear of there being damage or vandalism, but not necessarily enough to kick the person out, because it's not as you can do an urgent eviction application if you need to, if the person's destroying the property. But short of destroying the property or proof that they intend to destroy the property, you can't run to court urgently to get that eviction, but you can run to court to get access to the property in order to mitigate any of that damage from taking place. So just something to remember. A lot of attorneys might say, yeah, you can go and get an interdict to prevent them from damaging, but that doesn't help. It's a piece of paper that says don't do this, but whether they do it or not, you won't know because it's behind the wall. Getting a security guard in the property on occasion is not necessarily a cheap application, but it's worked many, many times where we've opened the door, put the security guard in, stationed someone, pending the outcome of the eviction application. So it's just an idea there. That does allow for entry to the property, but obviously you can't just necessarily barge in and break locks and stuff like that because that's unlawful. And so you always do need the court's assistance. The next piece of legislation, and this I'm going to keep very basic, so I'm not going to go through the general supply chain process on the Consumer Protection Act and necessarily even the defects and the like. We will be touching on this. We will be touching on this at some stage, especially when it comes to the mandatory disclosure form in the PPA. So I kind of leave that discussion for there. Over here, I just want to, and again, not necessarily a lot of estate agents know this. In fact, it's not even an estate agent thing. A lot of attorneys don't know this because I've had this debate with many attorneys. Does the Consumer Protection Act apply to lease agreements, right? Now, Consumer Protection Act applies to fixed-term lease agreement, fixed-term agreements. Now, a lease is fixed-term. So the assumption is, yes, it does apply. And this is the legal opinion on the top law firms in this space. Now, aside from both people, the landlord and the tenant being juristic persons, in which case it doesn't apply, the Consumer Protection Act would typically apply, especially if it's in the landlord's scope of business. But now, remember, renting a property and getting rental income from a property is a business. Therefore, it's in the scope of business. It doesn't say their primary business. It just says a business. So leasing a property, in our opinion, is covered by that because you're making profit. If, for example, you were to rent it to your brother-in-law at an amount that just covered your bond, yes, maybe there the CPA wouldn't apply. But provided that you're trying to draw an income for it, even if you're making a loss, but the thing is, it's there because you're trying to draw an income, the CPA will apply. Section 14 of the CPA does have a limitation no longer than 24 months, which typically isn't a problem because I see the most leasing agents only do contracts up to 12 months, so nothing more than 24 months. I will also have a discussion a little bit later on the CPA and the cancellation, the demand and cancellation of lease agreements, and the 20 business day rule. But I'm going to do that when it comes to the legal solutions component. But just bear in mind, the CPA does also govern how one actually goes about cancelling the lease. It's important to just mention for those that might not know, the tenant also has a right at any point in time to cancel the lease agreement on 20 business days notice. They can. So they can get out of that lease. So even if it's for a full year, they can cancel it in month 1. We need to know this. We need to understand this. As a consumer, it's their right. But, and the landlord needs to know this, because most of the problems come in where the landlord doesn't understand this, because you show him a lease for a year and then the tenant cancels and he's totally surprised by the fact that they're entitled to cancel. But the solution to this, or the silver lining, is if they do cancel, we are allowed to charge a reasonable cancellation penalty. So as Century 21 agents, I'm assuming that the lease agreement that you guys use does have scope for a fixed predetermined cancellation penalty. If it's not predetermined, it's something that can be justified. Very often it's linked to the amount of time it would take to find a new tenant on very similar terms. That's the old rule of thumb when it came to damages, but there are other things, as you'll see there, that we can use to actually determine what this cancellation penalty would be. And yeah, the landlord doesn't have a similar right to cancel. There are things that, for example, the sale of a property, special provisions that can put in that allow the landlord to cancel early. Construction and sale of properties, you can provide for in your lease agreements, that is allowable. But typically speaking, the rule is the landlord cannot simply, at a whim, cancel a lease agreement. They don't have the same corresponding right. They are bound. Unfortunately, it is the Consumer Protection Act, so it looks more at the consumer than it does at the landowner. Property Practitioners Act, most important clause in the Property Practitioners Act that when it comes to leasing is, in my opinion, Section 67. So I'm not using this platform today to do a talk on the PPA and its application and registration of estate agents, and whether, how the PDEs work and when you need to register, and, the tax clearance certificates and the BE certificates. We've actually done this many, many times. If you go on my YouTube page, I've spoken about it to death. And unfortunately, as the Act unfolds, we're going to be speaking about it more and more and more. This is just a provision specifically in the Act that's worth mentioning. A property practitioner letting agent still requires the mandatory disclosure form to be disclosed to the lessee or the tenant. And it is very important to do this. Number one, you're not allowed to accept a mandate if you don't. Criminal offense if you accept a mandate if you haven't asked for that mandatory disclosure form. It's also a requirement that you put it into the lease agreement, or at first disclose it and then insert it into the lease agreement. It doesn't necessarily give the lessee a right to cancel the lease if you haven't, but it opens yourself up for liability, because especially with high value leases, and you find this a lot when it comes to commercial space. So maybe with residential space, a person might ask, but what damages could a lessee possibly suffer? They move in, they look at the place, everything looks okay. They won't be suffering any damages. Potentially. I mean, there's certain scenarios where with mansions or larger houses, where there could be very specific things in the unit that a tenant expected to be working, and now all of a sudden he finds out it's not working, and there's a claim for damages that he has because it isn't. But what you find with commercial spaces is this is very, very crucial, because commercial spaces, there are things there. We can have conversations about issues with foot traffic. I had a conversation once where we brought a very similar concept, because it was a shopping mall that sat at the edge of 2 taxi districts, which meant that no taxis actually went through the districts. They only worked around it. And because they were simply on the edge, they got very little foot traffic, because no one from one district went to another. And the mall knew this, which was why it was in financial difficulties. But he didn't mention it to the tenants, who were relying on taxi foot traffic, thinking that because there was a taxi rank close by, that they would have the people coming in. But it turns out that they only had the people that were leaving from there into another space. There was no one actually coming through the space. So it's just something to consider. It is a requirement. If a tenant does happen to suffer damages because of your failure to do the disclosure, you may actually be held liable for not having done the mandatory disclosure form. Then the provincial Pie, please, Pie, it's way too long. So Pie is going to be dealt with by Alexis. I'm not going to touch on it now. She'll do a little segment that runs you through the process, predominantly so that you understand not to be an attorney that does evictions, but to understand what to tell the landlord about evictions. A last from me. All right, I'm almost hitting that 7-minute mark. A last from me when it comes to the basics of lease agreements. So this is that 101 approach to leases. When you have a tenant, and typically the problems we experience, and that's more what this talk is about, is bad tenants. We're not necessarily speaking about the environment of the relationship when it's good, inspections and stuff. We can do that at another stage. We're dealing with when the relationship goes bad. Specific performance, cancellation, and damages. Those are the three things that people can typically ask for when it comes to lease agreements. Specific performance, pay me the rent. Cancellation, you know what? I don't want you on the property anymore. Get out. Damages, oh, you're still on the property even though I told you to get out. You now need to pay me the value of the rent. It's called damages because remember, rent is a legal contractual term. A person only pays rent if they're a tenant in terms of a lease agreement. Once you cancel the lease agreement, they're no longer a tenant in terms of the lease agreement. They're there unlawfully. And being there unlawfully, they don't pay rent, they pay damages. And this is something very crucial, and I don't address it now, but I address it later, but I'm going to touch on it briefly. Very crucial. If a person stays on a property after you canceled, don't engage them any more than you have to without the assistance of someone from the legal department or myself or Alexa. Reason for this is I've seen a lot of cancellations that are basically, negated because people almost renew the occupation by telling someone, it's fine, just stay for a month and pay rent. What are you doing there? You're creating a new lease agreement that's verbal. So I'll speak about it a little bit later on, but just bear that in mind. Very, very crucial. So 3 things you can do. I'll run you by how to get the specific performance, how to do proper cancellations, and the damages we'll also touch on very, very briefly later. So now we're moving on to part 2. And yes, we are a little bit over time, 7 minutes, not too bad. And this is where Leonora is going to jump in. Leonora, are you there?
Yes, Bruno, I am here.
It's good to hear your voice.
Can you hear my voice?
Yes,
okay.
It's good to hear your voice.
Just thank you. Thank you, Bruno. So canvas outside control. Let's just make sure that we're on the same page here. Why does this look so funny?
So you've got control.
Okay, yeah. What are you seeing what I'm seeing?
I am.
As it
it's perfect. Yeah.
Okay, then. All right. Okay, thank you. And thank you for having me. So I'm the conveyancer at Bruno Simão Attorneys. And when I spoke to Bruno about the seminar, I said to him, you know what? It is so important that property practitioners also know how to deal with lease agreement when selling a property, because I think sometimes they just think it's the conveyancer's problem. Oh, it's not so important and stuff like that. So let's get started. So let's talk about the hier gaat voor koop principle. So the hier gaat voor koop principle was established long ago with the Roman Dutch law and has ever been part of the South African law. So the principle dictates that regardless of whether a lease agreement is agreement in respect of a property that is sold in writing, whether it's verbal or even a tacit agreement, the lease agreement will supersede the sale of the property. In other words, the new owner of the property will not be entitled to cancel the lease agreement based solely upon the new ownership of the property. The new owner will be bound by the material terms and conditions of the lease agreement, which is already in place. So the reason for this is because the right of occupation is transferred separately upon the purchase of the property. The tenant retained the right of occupation since this right has already passed to him with the lease agreement. and for the full term of the lease agreement. So this means that even in a situation where the landlord sells the property, the tenant's right of occupation remains unaffected. The only effect is that from the moment of transfer, the new tenant will pay his rent and fulfill his obligations towards the new owner. All right. So in terms of the huurgehadvoorkoop principle, it is applied ex lege, which means by way of law. The purchaser just steps into the shoes as the landlord. The contract doesn't have to be ceded. There's no formalities. He just takes over the lease agreement. So the huurgehadvoorkoop principle provides actually a type of security in the situation where the landlord intends to sell the property. So what is important here is full disclosure. What is expected from you as a property practitioner? So when listing a property, you need to establish, and I don't think this is so difficult now, people, whether the owner is occupying the property or if it's being let. Okay? And if it's being let, just make sure, is it a single letting, like it's a house and it's only being let to one family, or is it a multi-letting like student accommodation? All right. So you also need to determine, is it a verbal agreement or a written lease agreement? What is in place? If there's a written lease agreement, just ask for a copy of the agreement from the landlord or from the letting agent. Don't go on hearsay, oh no, there's such and such. Ask for a copy, read it, familiarize yourself with the terms and the conditions of the lease agreement to establish, is it a month-to-month lease agreement? Is it a lease agreement for a fixed term? Or is there the option that the contract may be cancelled before the expiry date of the lease agreement? It's important because this is the kind of information that you have to convey to your prospective buyer. So if it's a verbal lease agreement, which will usually be in the case when a landlord is doing a private letting, then this is my opinion as conveyancer, because I always see the backlash of all these problems when I attend to the transfers. I would recommend that the basic terms and conditions of this verbal agreement is stipulated in the MDF, the mandatory disclosure form. If you do not stipulate it at the special conditions of the contract, put it in the MDF. For example, let's say what would be, there is a lease agreement on a month-to-month basis. Actually, it would be more in the case of a long-term lease agreement, because month-to-month we can deal with during the transfer. But now let's say there's a verbal lease agreement. It's on a month-to-month basis, or it will expire the end of June. It's for 5,000 Rand a month. 2 months notice must be given to the tenant, and so on. That it is disclosed. So if there is a fixed long-term lease agreement in place, obviously, so if you just think about it, why is it so important? Why do we have to put these things in? Because as I say, if it's a fixed long-term fixed agreement, then you cannot sell the property or market it to people whose intent is to move into the property and occupy it as a main residence. But on the other hand, if the prospective buyer is looking for an investment property and you have all the information on the existing tenant, payment records, how long he's been there and everything, then this can sweeten the deal for the buyer, as you will not have to look for a tenant after registration. With a long-term lease agreement, I think it is important that the owner discloses the payment history of the tenant, as this may influence the buyer's decision to purchase the property. Nobody wants to buy another landlord's lessee problems, okay? So why I'm saying this is I am currently busy with a transaction where the contract, the sales agreement, clearly stipulates that the seller will give vacant occupation at registration. My client was adamant the transaction may not register in the deeds office if the property is not vacant. Why? Because the seller was clear, he was full disclosure, this is a problem tenant, okay? And he said, you know what, I don't want to inherit this, make sure that he's out. Now, the tenant came about and he has produced a long-term lease agreement only ending next year, June. My client is now stepping back and say, whoa, whoa, whoa. It was never my intention to take this tenant over. I do not want this tenant in this property. I do not want to inherit it. And it's for this reason that I say, property practitioners, please, the responsibility is with you to make sure that you have all the details of the lease agreement. So let's talk about completing the OTP when we know that there is a lease agreement in place. So I would recommend that at the clause that deals with occupation, that you write in occupation will be given at registration, which we usually put in, but I would just put in there in brackets, subject to the existing lease agreement. All right, because we know there's a lease agreement. Then I would recommend that at special conditions that the following clauses are put in. So for a month on a, if there is a fixed lease agreement in place, I would put the following wording in to say that there is an existing lease agreement. And what does this note say? And when it expires? No, that note is not right. It would say it is recorded that there is an existing lease agreement that expires, for example, on the 30th of June. So the buyer knows it is recorded that there is a lease agreement. He acknowledges that he knows that the tenant's going to stay on until the end of June. If there is a month-to-month lease agreement, I will put in, the seller shall give notice to the tenant in terms of the lease agreement, which will be 1 month or 2 months, once the purchaser has complied with all the terms and the conditions of the agreement of sale. Why are we putting that specifically in? It's because we want to limit the seller's damages. You don't want to advise your seller, oh, sir, the property has now been sold, give notice to your tenant, let him move out. But the purchaser has not yet complied, he has not obtained a bond as yet, or he has not paid his cost, or he hasn't signed as yet. It is a safe net for the seller. We can always accommodate this with the purchaser and say, listen, when are you going to move in? And we can work around that, because some purchasers also have to give notice where they are, and we have to just link it up. So when can you move in? Now I have to give notice the end of April to move in the end of May. We don't want the property to be vacant for security reasons, for loss of income for the seller, and so on. So one just has to be mindful, take everything into account and word the clauses correctly. But there's another condition that you can put in, is one that says that if the purchaser acknowledges that there is a tenant in the property, he is satisfied with the tenant's payment history and is willing to take the tenant over. Whether it's, this is not one necessary on the long-term fixed agreement, because remember, hier gaat voorkoop. The purchaser does not have a choice. He must know that there is a long-term fixed agreement in place, that the tenant is only going to move out in 6 or 7 or 8 months' time. This is where there's an existing lease agreement on a month-to-month basis, and the purchaser says, you know what? I've bought this property for an investment purposes. I will take over the tenant. Then I will put in there, the purchaser shall take over the tenant on the terms and the conditions of the existing lease agreement. If it is an oral lease or verbal lease agreement, we can put in, or sign a new lease agreement with a tenant after registration. Then we usually encourage the buyer or the new buyer to say, listen, this is the tenant. You are welcome to go talk to him, go make sure and say you are the new owner, you're going to take over at registration, will be more or less at that or that time, that we can just facilitate this, because you don't want the new owner to turn around after he said he's going to take over the tenant. We did not give notice to the tenant, and now the new owner comes and says, why is this guy not out? Say, no. You said you're going to take him over, or he turns around and says, this is a bad guy, he didn't pay me, or anything like that. We say, sorry, you said you're going to take it over, you're going to sign a new lease agreement, it's no longer the seller's problem. Okay, so I'm almost there. So let's talk about intentional misrepresentation. So as I said, it is the responsibility of the property practitioner to do a proper diligent search and collect all the information on the property, the tenant, and everything. It is not the responsibility of the conveyancer to sort out the tenant. All right. So I always say that the OTP, the offer to purchase, is the Bible. Whatever's included in the contract, the conditions that's been written in, is what was agreed upon between the parties, and we as conveyancers are guided by those terms and conditions. All right, so we need full disclosure. So what will classify under misrepresentation are the terms and the conditions of the lease agreement which was not being disclosed to the buyer. So as with my example that I've just mentioned, that seller, I mean, if this tenant now came about and sends us a written lease agreement, long-term lease agreement that's still valid for another year, then obviously the seller must have known about that. And that was a fraudulent misrepresentation by not disclosing it with the intent to defraud the purchaser and to persuade him to sign the OTP. So that will have certain consequences for the seller. It can, the purchaser, and that is what we are currently going to try and do on this matter, the purchaser can turn around and say, no, you know what, it was a fraudulent a misrepresentation, and I am withdrawing from this contract due of the seller's conduct. Or will it now be the property practitioner's conduct who did not do his job properly? Did the seller disclose it? Did the property practitioner not disclose it? The alternative also would be, for example, to say, okay, there is still 8 months left of the lease agreement. Can we retain 8 months rental on trust pending the running out of the lease agreement and ensuring that the tenant does pay? That would be a form of damages, limiting the damages of the new owner. All right. Then let's talk about vacant occupation. If the contract stipulates that vacant occupation must be given at registration, the seller has to ensure that the notice is given in time, and the conveyancer must then ensure that the property is empty at registration. So this will be a little bit of a coordination story, like, and sir, when are you giving notice, and try and register it as close as possible to the end of the month when the tenant must move out. If it is now clear that the property will not be vacant at registration, one has to anticipate breach of the agreement by the seller. That is his failure to give vacant occupation. Sometimes people do not foresee it. I had a horrible matter. It was absolutely horrible. The tenant said, no problem, I'm vacating. They've got another house for him to move in. And my seller said, it's no problem. The agreement is in place. We've arranged everything. Vacant occupation will be given. Unfortunately, the end of the month fell about on a Wednesday or a Thursday. And needless to say, that tenant or occupier did just not move out. And months later, he still did not move out. And when stuff like this happens, then it goes over to Bruno. And Bruno, that does everything that he does with evictions and stuff like that, then this matter becomes a litigious matter, and it goes over to Bruno. So I hope I have helped you with some with some legal aspects, how to deal with letting and how to word the contract and what to do when listing the property. That's my input for the day. Thank you, guys.
Thanks so much, Leonora.
Can you take over the slideshow?
I will. Thank you so much for making time. And yeah, we'll chat very soon.
Thank you, Bruno.
Cool. All right, so next slide. I just want to put my thing on full screen. There we go. All right, so the next section is going to be number 3, legal solutions. So over here, we already start touching on the need for coming up with some of the solutions to all the problems that we've discussed. So Leonora discussed a lot of things. She gave a lot of solutions on what needs to be in the contract and how to approach it and what some of the implications or consequences are. But if those don't work, for example, so those are preemptive by their very nature, simply being that you're trying to contractually bind people to do things. When we start speaking about some of the solutions specifically today, it's not necessarily just the preemptive solutions. We're also looking at the post solutions. So basically trying to fix an issue once it's arisen as opposed to prior to it arising. But as Leonora very correctly points out, the reality behind it is if you can try and govern and manage, and this is what I mentioned in the first few slides, is what Leonora mentioned as well, and you're going to keep hearing it from a team of attorneys that has seen too many problems, and we're now adamant to try fix them before they actually arise. So if you put a bit of time and energy into the support and into preempting and being proactive in your approach to these problems, you're going to come out on top. Yes, it might take a little bit of time beforehand, and it's actually very interesting. It's a concept that's called sharpening the saw. Sharpening the saw basically means, and I mean, the analogy is, I walk into the woods and I find a person there chopping down a tree or sawing a tree, right? And he's been there for hours. He looks tired. He's completely exhausted. And you ask him, well, what are you doing? Why is it taking so long? And he's like, it's very difficult. The saw just isn't sharp. And your solution to the problem is, okay, well, take the saw out, sharpen it, and then start again. You could probably save a lot of time by doing that. And his answer to the problem is, I just don't have the time to stop. I need to keep sawing. And we see this consistently in our practices. I mean, we experience it as business people. We experience it as property practitioners. I experience it as a lawyer. We get so busy that we don't see ahead and try and preempt and be proactive. We're constantly trying to be reactive. We're trying to fix things once they happen. And you're working in a quadrant that makes it very difficult for you to be on top of things, because as soon as you fix this, something new happens, and now you're trying to fix it, and you're working on a very urgent and important sort of thing, as opposed to trying to focus on just important without the stress of the urgent. So very, very crucial that the first 2 sections of this be taken to heart before we move into the third section. So the third section is, okay, it's happened. How do we deal with it? How do we manage? How do we allow the landlord to be informed or skills transferred so that they understand what the next steps are, so they don't have false expectations, so that they don't get upset with you if something does go wrong. So this module or this topic serves 2 purposes. It's number 1, the ability to educate the landlord, and number 2, if you got to do what you got to do. If you really haven't been able to sort out the problem, this is solutions that we have to try and get it resolved. So I'm going to briefly be speaking about spoliation. I have to touch on this. Not a lot of people know what it is, and this touches for sales agents and leasing agents because it is crucial. What is the spoliation? What are the consequences? How to engage a difficult tenant. I think I've spoken enough about this, so I'm not going to necessarily touch on it again, but I put it there just, as a reminder, so you guys recall that is actually something that you need to bear in mind. The start and finish of an eviction, that's where Lex is going to jump in and speak about it. And then I'll be speaking about possible debt collection solutions. The reason why we mentioned debt collection when it comes to this is a lot of landlords do want to try receive their money back. So we look at what the solutions are, whether they're realistic solutions, and again, managing the landlord expectation. All right, so let me start with the spoliation. So spoliation, insofar as being 2 sides of the same coin, the reason I say this is it's such a strange world out there, because us as landlords have the expectation that we own the property, we are able to determine what is done with it, and our law, because I mean, this is a statement I hear all the time, the law is not fair. South African law, it's unfair. Basically, the word fair gets used a lot, or at least it's being unfair, right? But there are two sides of the coin, and I always start the conversation by saying, guys, just bear in mind, if you're on the other side of things, would you appreciate this level of legal structure that we have? Because South Africa actually has a very decent legal system. We don't realize this. Our deeds office is incredible. It's top class. It's one of the best in the world. There's some countries out there where you don't even know what properties you own, or the government doesn't know. No one knows. So you can be selling a property that belongs to somebody else. No one would know any better. Ours are so well recorded that simply does not happen, or shouldn't happen at least. Our judiciary, we've got some great judges out there, and the history, or the foundation of our law is very strong. So we take our law from Roman law, Roman Dutch law. We borrow certain concepts from English law, Australian law. Our tax law is English, Australian, New Zealand. We've got, there's a lot of borrowed concepts. There's a lot of backing and knowledge that comes behind our law. So these principles exist because they serve two purposes. And spoliation specifically is one that people always get annoyed with me when I speak about, because it just seems so unfair. Ultimately, what is a spoliation? So it's the wrongful deprivation of another's possession. So off the bat, from a definition perspective, it seems okay. It's like, okay, a spoliation is when I take something that somebody else had. So it sounds like theft, but it's not. It has nothing to do with theft. It has nothing to do with rights to the property. It just has to do with literally taking something that somebody else had. Now, the objective of a spoliation order is to restore the status quo. That means if you take something that somebody else had, that person that had it is entitled to get a court order to restore it to them, right? Now, the principle behind this is no one should take the law into their own hands. If you wanted to take what that person had, you should have done it the correct way. When it comes to property, the correct way is typically by way of an order. So if you want to repossess a property that belongs to you and you want the tenant to vacate the property, we have laws in place that govern how this is supposed to take place. And this is where the unfairness argument comes in, because everyone's attitude to this, or a lot of people's attitude is, but it's unfair. I need to follow this process and the tenant gets to do whatever they want. But remember, two sides of the coin. That's not always the case. So you as a landlord in your daily life, if you have something, you're in possession of something, let's say you're in a dispute with someone and you feel that you own this, and they come and forcefully remove it and take it away from you without asking, that protects you. So this law applies in general application, and we need to realize that, yes, it may seem very unfair when it comes to landlord or leasing law, but the reality is it applies across the board in your benefit as well. And that's what I mean by the two sides of the coin. It can also protect you, not necessarily under these circumstances, but other circumstances. And unless we actually respect the law is there to assist to a certain degree, not always most efficiently, but it is there to assist to a certain degree, we can start working towards making it more efficient, as opposed to trying to push back and saying that it's unfair. The law itself isn't unfair. Maybe how long it takes to go through the courts might be unfair, but that's a political issue. That's a resources issue. That has nothing to do with the judiciary and the judges and the laws. The laws are solid. That's not what's causing the frustration in our country at the moment. Just food for thought. So spoliation effectively is taking somebody else's thing without by force, and unlawful deprivation. So technically, even if it does belong to you, but you take it without getting a court order, it's spoliation and it's unlawful. And what happens in those specific instances is the person is allowed to acquire an order in order to have this returned or restore the status quo. So So the wrongful nature, I'm not going to go into detail. I mean, we all understand the basic principles of what is wrongful. Possession, so remember, possession is a funny one from a definition. I have to say this when it comes to property law, is the person need not necessarily be inside the property when you lock it, right? Because locking up, and it's the funny thing about deprivation of possession. It's very easy to look at a movable item like a cell phone, say, and the removal of a cell phone from one person's hand to the other person's. That can be a dispossession, and it's very easy to fathom this. But when it comes to property, it's never always as simple as, well, I open the property, I step in, and now I've got possession, and that person doesn't have it anymore. As long as the person has things inside the property, as long as they're exercising a degree of possession over that property, even if the property is locked and they went overseas for a month, they're still exercising possession of this property. So short of actual abandonment, which is clear, a person abandons a property, they've got no intention on returning to the property, provided that they intend exercising possession over that property, even through a locked door, and they go to work on the day. You going and changing the locks on that door is considered dispossession, because at that point in time, you've deprived them of the right to access their property. Whether they want to access it that minute or later in the day is inconsequential. You've deprived them of that right. So just bear that in mind from a possession perspective. Changing the keys is dispossession, because now they can no longer access that property. Consequences. So this is a very practical statement, and you'll see from our talk today that we do try and get into the practical nature of things as opposed to focusing just on theory. So there's a theory component to everything, but what does this mean? What does it mean? So where is this applicable? Your landlord. Now, and this goes back to landlord management, if you've set the wrong expectation with your landlord and he feels that an eviction is like this, and now it transpires after he's had a conversation with me, for example, because you didn't bring me in sooner, now it transpires that evictions are going to take longer and it's going to cost a certain amount of money. This is when you find that people resort to things like this. And unfortunately, they're very upset with you because you didn't explain to them what the reality behind lawful conduct was. So now they want to try do things unlawfully. And it's like a big, big word of warning. If it ever gets to a point where they try and get you to do this, please don't stick your neck out, because I've seen many, many, many times estate agents performing acts of spoliation on behalf of landlords. And it's normally out of desperation because you want to keep this client happy. You don't know what to do. The expectations weren't necessarily managed at the beginning. So now they've got higher expectations of you than you can actually perform. And you go put your neck on the chopping block for them. And it's dangerous because remember, you guys have certain ethical standards. You've got now the Property Practitioners Authority that you need to report to. Certain conduct is not going to be accepted very well. Now, depending on whether the PPA actually enforces like the ethics and the rules of conduct and how good they're going to be at this is a different conversation. What I'm saying, though, is you're putting yourself on the line. If anything happens in that process, and I'll discuss damages, for example, you'll see that the second point from the bottom. We had a case where a client conducted spoliation, locked the door, but the person staying on the property stayed with an elderly lady that had heart medication. And as soon as they locked the door, they couldn't go in to get the medication, and then it started becoming late. The person landed up in hospital. There were hospital bills. She could have died. But and guess on who that falls. So as a landlord, my client was the landlord. He basically had to take responsibility for that. He allowed them to sue for damages, and eventually he had to settle. But the reality behind it, as an estate agent, something like that happens to you, it's on you. The landlord's going to throw up his hands and say, well, I didn't ask him, or it wasn't a solution. I didn't understand the nature of the solution. The estate agent made it available to me. I thought it was okay. Be careful, guys. You're property practitioners, you're professionals. You conduct yourself as professionals. There's lines that you can't cross. Handle people. Managing people is one thing, but crossing the lines into spoliation becomes dangerous for you. If your client wants to do it, you know what? Nothing you can do. Let your client do it. I've had to let plenty of clients do it. And that's where the 9 out of 10 principle comes in. But this has nothing to do with you guys. If the landlord has multiple properties, he feels that he gets away with it 9 times out of 10, you're going to find that he's more inclined to partake in unlawful conduct than a person, for example, that has one property. So understand your clients, understand which ones are more inclined to do certain things, because there your management of their expectations is actually very crucial. Some guys are a bit more naive or new to the game, so they'll listen to everything you say as and when you say it, versus a guy that has multiple properties that you might need to manage from the beginning and say, I'm not willing to do something like that for them. So that's 9 out of 10 principle. Get it right 9 times out of 10, more likely to do it. What people don't often realize is that 1 out of 10 is a bit of a mission. So as an attorney, I deal with the 1 out of 10 as an example. And the reality is this ratio is actually not right. It used to, like at a stage, it was 9 out of 10. People know their rights now. Tenants know their rights. Rental Housing Tribunal now deals with this. So you need to remember, because of the Disaster Management Act, spoliation became a big thing. It was outlawed, if you will, in terms of the regulations for the Disaster Management Act. So it was thrown in your face how illegal it was and how much of an offense it was. So whereas in the past there were still questions, some tenants didn't understand their rights and went, oh, well, I didn't pay rent. They locked the door. It's allowable. Now they went, sure, this says that no one can kick me out. Public rights organizations within the COVID period made a big noise about how locking doors, and I mean, they made a big noise about how not paying rent is okay. So locking doors and things like that was completely out the question. So just bear in mind, nowadays, it's more like, I don't know, you come right maybe 6 out of 10 times, 5 out of 10 times if you're lucky. And to come right, I mean, no one says anything. It's still unlawful, but no one says anything about it. It's not actually right. But the problem is those 5 out of 10 where it doesn't work are a mission, because they can go to court. So a lot of the times, especially magistrates courts, they can get orders against you ex parte. What that means is they can get the order against you without you even knowing that they're getting the order against you. So you'll have a sheriff pitch up at the property at 6 o'clock in the evening. You won't know any better, and they will rip everything open. Very often they'll break locks and break chains and things like that, and you're probably in for more damages than it's worth. If you go to court, a lot of the times they get a cost order against you. So that's dangerous. So now you need to pay the person's cost for having done this if they appointed an attorney to do it. If you go and oppose it, the costs are even higher, because now you're paying your costs and the potential of their costs. So spoliation is a bit of a touchy one. There are certain ways of defending it, but you know, the basic principle of dispossessing is often very difficult to defend. And I'm not going to go into detail on different exceptions and things like that. So out of this, like, let's call it the 5 out of 10 principle, they get reinstated to the property. You know, it doesn't necessarily mean that all of a sudden they're going to start paying rent. So you're still stuck with the person that's not paying rent. You've now actually committed a criminal offense. You, landlord, this is also in case you need to prepare the landlord for what's to come. Damages, like I explained to you, I mean, the hospital bills were a typical example, but I've seen people charge for hotel stays, guest houses stays, finding alternative accommodation for the evening, for the week, or whatever the case is, depending on how long it's taken for them to find or to get the property back. So that's a big one. And then the negative inference is also a big one. So remember, there's a legal principles regarding eviction are set in stone, yes, but there is a level of, call it fairness, that a judge will consider within the legal scope of things. Now, fairness deals a lot with the circumstances of the occupier. So if the occupier is rendered homeless, if the occupier is elderly, if the occupier is a female who heads a household, if there's multiple children on the property, these are all things that the courts will consider. Now, what you're doing now by doing a spoliation is you're taking a point away from you. So you're the owner. You need to pay. You need to pay the bond. It's unfair. But now you're going to do something unlawful. Judges are still human. What are you going to find is going to happen? you're creating a negative inference about your conduct. This tenant can then say certain things in the papers about how you acted throughout the lease and you made things intolerable. And the worst part is now they're more likely to be believed than you or your landlord. So be very careful with that, guys. All right, so that is spoliation. I'm going to bring Alexa on now for the eviction, and we have about 15 minutes. I still need to touch on debt collection, so we might run a little bit over the half-past mark. But Alexa, take your time, yeah, and enjoy.
Oh, okay, I've just taken control. So let's see if this, okay, perfect. Hi, everyone. As you heard earlier, my name's Alexa Levendal, and I will be talking to you about evictions and how we go about the process and just a few things here and there. So the first thing I just want to speak about is I have personally had a few evictions where the agents, whether it's rental or leasing agents, and through no fault of their own, didn't know a lot about the eviction or the process. And as Bruno mentioned earlier, it kind of caused a bit of a damaging effect with the agent and the landlord, because when they come to us and they hear a different situation, it kind of makes them kind of skeptical. So we think it is very important because there is that possibility that before you guys come to us, your landlord or your client is going to ask you, okay, so what do I do next? So the first thing I'm going to start with here is, what is an eviction? So just a small definition. An eviction is the removal of a tenant from a property by the landlord. It usually stems from a breach of an agreement, but it doesn't have to. So there are different ways where evictions can be started. So as you can see, a tenant cannot pay rent, and then you can terminate. A tenant can refuse to vacate the property after the lease has expired. Or what we call a no-fault termination is where the lease is just terminated. Maybe you're selling the property and the new purchaser doesn't want a tenant on the property. So there are a lot of different ways where an eviction can be started, or different reasons why we can start the evictions. Okay, then we have two different types of evictions. And I think Bruno also touched on this, but I'll go a bit more into detail. So there's unopposed evictions and there's opposed evictions. So yes, it kind of tells you the story for itself, but let's see what the difference are. So in an unopposed eviction, only the landlord, so only your client, will have put their version before the court. And that generally takes about 2 to 5 months. Obviously, now with the whole COVID situation, we aren't 100% sure how long it can take, because it's very up and down, but generally 2 to 5 months, depending if it's match court or if it's high court. Then in opposed evictions, so this is generally where the people get a bit scared, because both the landlord and the unlawful occupier will put their versions before court. So yes, it's quite a bit longer, and yes, it's a bit pricier, because there's a lot more documents that have to go before the court and a lot more time frames that have to be attended to, and more hearings as well. Okay, so let's go through this eviction process. So here at Bruno Simão Attorneys, I'm not sure if other people have different processes. This is our process. We have a 5-phase process. Okay, if I'm talking too fast, please just let me know, and I will slow it down, or if I must take it back, just let me know as well. Okay, so we have phase 1. This is the termination. So the first step we obviously take is the letter of demand, but this is obviously only if it is necessary. So with the letter of demand, if we're doing a no-fault cancellation, that means there hasn't been a breach and we don't have to send the letter of demand. Then we send the letter of cancellation or termination and the notice to vacate. So in this letter, we let them know, listen, this is the lease agreement. Either this is when it expired, or we are terminating it based on this reason. You have this many days to vacate the property. We have to give them time to vacate the property sometimes because of what is said in your lease agreements. So you as the rental agents will know, if your lease agreement states we have to give them a month's notice, then that's what we put in the letter of termination and notice to vacate. Then we have phase 2. And phase 2, yes, is my favorite part because I love the drafting portion. In the main eviction application, we put down all the facts that happened from the time the lease was started until where we are now. So we'll have to put all the facts in. How much rental was paid, when the lease was supposed to terminate or expire, why we're cancelling, just so the court also gets a good rundown on why the matter is taking place. Because we definitely don't want to get to the main eviction, the actual hearing, and the court asks a whole lot of questions. Then once we've drafted this document, the sheriff of the court, he will serve it on the unlawful occupiers. And that definitely needs to take place. So then we have phase 3. This is the section 4.2 application. So this is a legal requirement from the court. So we have to now tell the unlawful occupiers and the municipality when the main application hearing is going to take place. So this is more of an ex parte application. The actual tenant does not have to be at this application, but I mean, sometimes they rock up to our dismay, but that's also fine. So this is just giving the tenant and the municipality. So remember, in this whole process, the municipality does have to be a party to the application because, like we state in our papers, it isn't our client being the landlord's fault. I mean, not fault, sorry. The landlord's job to find them new accommodation. That is the municipality's job. Then we have phase 4, and this is the actual court hearing. So during this hearing, this is where we get an advocate or an attorney of the High Court to approach the judge and actually go through the papers with the judge, getting the actual court order. So I'm not sure if we've spoken about this yet, but you cannot evict a tenant without a court order. And this phase 4 is the portion where we get that court order. Then phase 5. So phase 5 is the big finale. And this is where the actual sheriff, we give him the court order and the warrant, and he goes to the property and forcibly removes them from the property with help of a locksmith, the SAPS, and yes, guys, sometimes it's necessary to use the red ants. As Bruno mentioned earlier, we have a lot of evictions in the inner city buildings, so sometimes it gets a bit hectic, but we get it done. So this is a very it's a very short description of the eviction process. And obviously, if you guys want any further information, you're welcome to contact us. You're welcome to ask us, please ask us questions. We love getting questions. But this is just a very basic rundown of the eviction process. And I personally do think it's very important for rental and leasing agents to know this, just in case you do get those questions from your clients. I mean, I know I get a lot of questions and I'm like, oh, I really wish I spoke to Bruno yesterday. But this is just that kind of process. So please, if you have any further questions, send us a message on the chat box or contact me at any time. Thank you, Bruno. Are you there?
Yes, I am. Thank you, sir. I've never met someone so upbeat about evictions. Well done.
You got to get that paper.
Excellent.
So
okay, cool. Awesome.
Cool.
Thanks so much. You're gonna stay on for the Q&A.
Yes, I am.
Yeah. Cool. Awesome. So let's move on. Right. Next slide. There's a nice little thank you slide there. You missed it. Okay, there we go. All right. So demand and cancellation. So where we are now is we still addressing legal solutions. We're now taking it up a notch. Alexa did speak about it. So technically this part should have come before the eviction component, but I normally do the debt collection afterwards. Reason for that is eviction is more important. It has to be dealt with. It has to, people need to get out of their property because you're losing money continuously on a monthly basis. So we need to sort out the eviction first and foremost. Collection of arrear rental takes a side seat, or you know exactly what I mean. Takes a step down. It's not as important, and a lot of landlords are willing to take a hit if they can get the tenant out of the property. Now, this leads to certain permutations, which are very, very crucial. So, and when I spoke earlier, and I had it on the agenda about managing the tenant, another component that I didn't speak about before is, remember, it's not ideal to pay a tenant to move out of a property So it's not something I would go out and promote. And it's certainly not something I'd go out and tell landlords, well, it's fine. You know what? If he doesn't pay you rent, we'll just pay him to get out. So it's not something that we want publicly out there, but as an internal conversation between us and you, what they're sometimes going to pay us as attorneys to try and resolve the problem for them, as opposed to giving a tenant a little extra money here and there, works as a solution. It's an option. I'm just saying it's an option. It's ethically, I struggle with it. Also promoting that type of behavior by tenants, I struggle with it, because this guy's going to go to the next landlord and next landlord, and it's going to consistently be a problem. And another problem that I've often experienced, and I'm going completely off on tangents, is the fact that when you list people using TPN, for example, it makes it harder to evict them. Because now they're trying to find a new place to move out. Some of them are even willing to move out, but because you've just listed them as non-payers, they can't find somebody somewhere else, meaning that now they're stuck on your unit, and it's kind of a rock hard place type of scenario where if you don't list them, you're doing an injustice to the rest of the industry. If you list them, it's an injustice to your landlord. So it's a bit of a tough situation. There's no right or wrong answer. I typically say, look, list, because you don't know. Like, some of these tenants are just difficult, and people need to know that they're difficult. We can't just keep having them run through the system and not get caught. And a lot of them will move out if dealt with properly, if us as attorneys jump in at the right time and deal with them. Very few of our tenant or lease evictions actually get to the opposed phase that Alexa was speaking about. So we're proud to say that about 70% of our evictions end on phase 2, because as soon as that tenant gets that application for eviction, they panic and they react and they move out. And that's the behavior you find. So giving the tenant money before that point is not the best idea. It is promoting or endorsing a certain type of behavior that you wouldn't want to as agents. But that being said, after that point, it becomes an interesting conversation. What are the circumstances around the tenant's occupation? We do a lot of this type of conversation when it comes to inner city buildings and purchasing properties on sale and execution, which is something we do quite a lot of, and doing evictions on previous owners, for example, that live on the property you just bought on auction, is where this type of solution really plays well. With rentals and leases and stuff like that, I would rather save it as a last resort. And so demand and cancellation. So before you can do an eviction, you are going to need to issue the demand and the cancellation. Alexa did mention it. So this is the repetition of it, but from a debt collection perspective. So now we're speaking demand and cancellation in order to debt collect. You typically do this at the same time as the eviction one. So one letter goes out demanding, one letter goes out cancelling. So only one. The reason I'm addressing it now separately is because I just wanted to also let you guys know about the time periods. So I mentioned earlier that the Consumer Protection Act, Section 14 applies. So if you remember from that conversation, if there were certain exclusions from the Act, then this wouldn't apply. But typically, if a person's making money or wanting to make money, the intention is to derive revenue from the rental of a property. Consumer Protection Act applies, meaning that Section 14 applies, meaning that in order to cancel a lease agreement, you have to give 20 business days notice to rectify the breach. Now, remember, this is different from what Alexa was speaking about, because in terms of the Rental Housing Act, if, for example, a lease hits a year, it starts going on a month-to-month basis, right? So you can give 30 days notice, no fault. It's not a breach. You just give a notice saying, please get out in 1 month's time. Thank you so much. You're out of the property. So that's the difference between a no fault and a fault cancellation. A fault cancellation is when the person hasn't paid rent, they've breached the agreement. Their Consumer Protection Act requires that you give them 30 days, 20 business days, to pay the rent. If they pay the rent, they've rectified the breach, you cannot cancel. If they fail to rectify the breach, on day 30, you can cancel. So in both instances, you're still looking at a period of 30 days. The difference is, on the no-fault cancellation, you're allowed to cancel. The lease has expired. It's a month-to-month lease agreement now. You're basically just terminating a lease agreement as you're entitled to. In the second scenario, they're still technically allowed to be on the property had they performed, and now you need to give them 20 business days in order to perform. I normally get a lot of questions. Around this this topic, so feel free, because sometimes the two types of cancellations are a bit confusing even for attorneys. You'll see at the bottom I speak about non-CPA a cancellation. Like I mentioned, your brother-in-law, you put him there, you're just basically covering your bond, no intention to derive revenue from it. Lease agreement says if there's a breach, you have 7 days to pay, you can give the person 7 days. Also, if CPA doesn't apply where, for example, it's two juristic persons. So if you guys are dealing, for example, with commercial letting, and you have two companies contracting with each other, landlord, tenant, you might find that provisions in CPA wouldn't apply if it's drafted properly. And again, that's legal solutions. So we do this for some funders as well, like financing houses that we work with, where we look for ways where some of the legislation need not apply so that it takes away all those bureaucratic steps that make things more expensive. So even here with commercial leases, I work with a lot of landlords and management companies that only enter into commercial leases with companies in order to avoid CPA from applying. So that's a cancellation. So before you can evict or collect, you're going to need to make a demand if it's a breach, and you're going to need to send out a cancellation notice if the person hasn't remedied the breach, or if you're just entitled to terminate the lease agreement, right? I mentioned this earlier, and this is what I'm going to mention it again. Please do not make the mistake. And that's why normally I have the conversation with estate agencies that by the time it hits cancellation, please hand it over, or let it be managed by a singular individual, for example, that engages with us very often. So what we do in this space, as an example, is we create support systems, right? So if we continuously get your evictions and we undertake them, we create support systems with the agents, and like WhatsApp groups and stuff like that, where people can ask quick questions. So I find that is a very good centralized point. Another option, for example, is a singular person, like a head of legal, for example, at some agencies that take on matters at a certain point. We engage with them so that we're on the same page and we build a legal process flow. Why? Because if you send out a letter of demand and then you send out a letter of cancellation, and after the letter of cancellation, for some reason the person pays and you accept it and you call it rent, you send out a statement after that that refers to it as rent. You allow them to stay on for a little bit longer. Whatever the case is, remember, you are now almost revitalizing the occupation. Pie, so the Pie Act that Alexa was speaking about, specifically deals with an event of occupation. So at this point in time, the person is in occupation of the property. Before you can evict the person, you need to lawfully terminate the occupation. So that means that their occupation just went from lawful to unlawful. That's not an automatic process. It happens when you terminate. Now that they're unlawful, the act kicks in order to allow you to evict. As soon as you change that dynamic and you allow the person to lawfully occupy again by giving them permission to do so, or by referring to words like rent, which is a contractual word for you're allowed to stay as long as you pay me rent to stay, you might face issues. Now, we can get past this. We've resolved this problem. I'm not, the use of the word rent has become acceptable in some courts where the magistrates understand there's just incorrect use of terminology, but depends. And sometimes further conduct other than the use of the word rent has caused issues where even if you started the eviction process, you have to restart it. If you've sent out a letter of cancellation, you need to give them notice again to remedy their breach and send out another letter of cancellation. And your client, the landlord, would be furious if you do 30 days notice, mistake happens, now you have to do another 30 days notice. So be very careful with that notice periods. CPA, very important. Legal solutions process to make sure that as soon as it hits a certain point, that there has to be some kind of verification on what an agent would do next. This works especially with newer agents that might not have listened to this. A guy starts tomorrow, hasn't listened to this. We need to create that process flow and accountability so that as soon as they hit this mark, they have to revert back and ask someone for help, or take it to a central point, or contact us on the WhatsApp group if we created a WhatsApp group, something along those lines. All right, so debt collection and other recourse. So I just want to go through this briefly again. I'm not here to make you guys lawyers. I'm here more to just give you the different options so that the landlord does understand. Now, first things first, and I think it merits. You know what? Let me go through the list and then I'll close with that. Landlord's hypothec. All this means is that a landlord, by law, has a hypothec, which is basically a form of security over the assets that are in the unit that belong to the landlord, and mind you, some assets that belong to the landlord, belong to the tenant, and even over some assets that belong to third parties. But we're not going to get into that today. So what does that mean? I lease out this unit. The tenant comes in, he's got his TV, he's got his washing machine, whatever the case is. He fails to pay me rent. Strictly speaking, if we forget and we ignore the legal processes for now, the reality is I can sell that washing machine, I can sell that TV in order to recover the rent that's due to me. That is the hypothec. I've got a greater right to those assets than all his other creditors because my hypothec stands for it. There are stronger rights, but we're not going to get into that today because then it becomes an order of preference. But let's just say against anyone else, generally speaking, that, it's like if these assets aren't subject to hire purchase, for example. So you don't have a greater right than a bank that financed the purchase of a vehicle. You don't have a better right over that vehicle, sure. But short of something that extreme, you'd have a better right than another creditor that he might owe money to on his clothing account or whatever the case is. So the hypothec is crucial because it's one of your best ways to collect rent, provided that the tenant has assets. So that's just something to consider, letting your landlord know that there is a possibility, but just keep your eyes open for what type of assets the person has, especially while you're doing inspections, because then you can actually advise your landlord on what you think the best course of action would be, right? Rental housing tribunal. So this is a quick way for a landlord to enforce his rights or her rights without incurring the cost of an attorney. You cannot do evictions at the rental housing tribunal, but you can try and do rental collections there. But obviously it takes up the landlord's time. I've seen a lot of estate agents do this on behalf of the landlord. And what we actually do is sometimes then we work and we do this on behalf of the estate agencies, and we try to go to the rental housing tribunal for various landlords for that specific agency. And we send like one of our candidate attorneys, for example, just for the sake of saving costs. So that's always something that we work with the agencies on, but like that, we don't go to court. So it's a bit less of a formal process, and it might be quicker, but it does have its downsides as well. Then automatic rent interdict. Now this kind of links up to the first one, which is the landlord's hypothec. If automatic rent interdict, so like pure and simple terms, I'm suing the person for the rent. Simple as that. I sue for the rent. Automatic rent interdict is just a fancy name for that specific summons, because the rules of court make provision for when you sue for rent, you actually get an interdict preventing that person from emptying out the assets in the unit. So this is great because under most circumstances, you don't have special summonses for anything. So this is the one summons in the magistrate's court rules that makes provision for the collection of rent and securing the landlord's hypothec. So it touches in with the first one. When you want to collect the rear rent, you go there with the sheriff. The sheriff knocks on the door, walks inside the house, looks at the assets, writes them down, and tells the guy, if you remove this, it's illegal and it's a criminal offense. Now, let's start thinking outside the box here. It's not just simply about now, are the assets of enough value to cover rear rent? This is a reality check, and why our evictions, 70% of them work within the first two phases that Alexa spoke about is because we push those reality checks so people wake up and realize that what they're doing is going to cause them more harm than it's worth. So something like this, for example, I always advise, even if you don't think you're going to collect the money, get the rent interdict out, because if it saves you 1 month where this person's occupying the property unlawfully and your rent says 10,000 Rand a month income and a rental interdict in total costs you 5,000 Rand, you're saving money. If the person had to stay 2 months, it's 20,000 Rand loss, which you could potentially have avoided by doing this type of reality check where the sheriff walks in, starts writing down all the property you own. You become fearful. Application in terms of Section 32 is more of an advanced step. So it again touches in with the landlord's hypothek. But in these instances, it's situations where there's a threat, a real threat of the tenant destroying or removing assets from the property. You can actually go in and attach these assets on the spot, and you can even remove them from the property. So this is a very nice way of ensuring that if there is any arrear rent, that you attach those assets, but it's an additional application. It comes at an additional cost, and you very often some guys don't want to use it because they'd rather the tenant move out, assets and all. So they're happy if they see the tenant leave, but in commercial properties, completely different story, because there it takes you months to get tenants anyway. So it's more valuable that you make sure that the fridges stay there, that stock stays there and all of this. So Section 32 application is actually very useful when it comes to things like that. And if it's not a Section 32, for example, it's just a general court process of the tenant's about to leave, lock the doors. You can get an interdict preventing them from removing the assets against the landlord's hypothek. Eviction proceedings. Alexa spoke about this in some detail already. Utility disconnection, not something that we use very often. We use it more with body corporates, but there are certain justifiable situations where if a person's staying on the property for long periods of time, not paying rent, and on top of that, not paying electricity and not paying for water consumption, you can actually apply to court to have these disconnected. It's not necessarily an expensive application, just an additional application. So it really depends on the environment. If you know that your tenant's going to be difficult, like you might find, for example, I don't know if any of you have ever experienced this, but let's say, for instance, you sell a property on behalf of a seller because he's in dire circumstances. A person buys it but allows the seller to stay on, and you start managing the rent. Now you're stuck with a previous owner that's very emotionally tied to this property. So getting him out is not going to be within that 70% chance of reality check. The oak's desperate. So what do? You might want to use things like this to kind of even the playing field in the sense of, well, if you're going to stay there illegally, I'm not going to pay for your water and lights. A lot of times, though, when it comes to situations like this, I often just advise, listen, and I mean, so I don't want to say this like as a quote, like don't quote me on it. I've seen scenarios that work really well where as a landlord, you go, I can't afford to pay the municipality. So if the municipality disconnects, there's nothing I can do because you haven't paid me. But if the tenant does pay you for consumption, you can't allocate it to rent. So if he pays you and says, this is for electricity, you have to pay it to the municipality. So it's only in situations where he doesn't pay you anything, or he only pays you rent, specifically rent, and nothing else, that you could allow the municipality to duly disconnect, because you know what, you don't have any cash to pay the municipality. Just be careful with that. Then access to property, I discussed earlier on. It's also a good application if you need to get access, if you need to secure the property, you need to do maintenance on the property. If it's a very expensive property where you want to start getting tenants in, or you as leasing agents, also remember you always have those clauses in your contracts and your mandates that if the property gets sold to a tenant, you get COM. You may very well also have clauses where, or they might come to you to just sell the property. So you might be able to benefit and get COM from a sale, but you need access to the property. There's a difficult tenant. You'd use this access application. Very high value properties, this works really well. Or selling properties where you're going to have an eviction issue, but a purchaser is willing to take it. Things like this work really well as well. But yeah, that's a bit more advanced strategies that sometimes we have to work with. It's few and far between, like rather the exception than the rule. All right, so that is the end of my presentation. Lex has done hers, Leonora's done hers. We're 14 minutes over time. Sorry about that. Leaves slightly less time for the Q&A. But yeah, before everyone goes, I just want to, there's a QR code there. Please, 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 if you enjoy this, feel free to scan the QR code, give us feedback. Let us know what you thought about it. If you do have any constructive criticism, feel free to contact me directly. Send an email to info@Bruno Simão Law. Obviously, then just send me the email. Tell me what you didn't like, if there was something you didn't like, or yeah, scan the QR code and tell us what you did like and what you'd like to see more of. But yeah, I'm happy to take questions now if there are any.
That was absolutely brilliant. Guys, can you see when I said in the beginning, this is going to be a jam-packed session and that these people are absolute legends at what they do. They absolutely know what's going on. They know exactly what is the right thing to do, what is the wrong thing to do. So I hope you guys enjoyed that. So we're going to jump to questions and answers real quickly. So just before we jump to questions and answers, because I know some of you might want to slip off for the questions and answers, but if you can, please stay. If those of you have not done the C21 rental training on the Training Academy, please go and do so. So the rental training on the Training Academy is 3 modules, okay? Module 1 is all about the laws and the acts that govern rental. So it's about the Rental Housing Act, the Rental Housing Tribunal, the prevention of illegal eviction that they've mentioned, the EAB, the PPRA, the Rental Housing Tribunal, all of those things, the CPA and how it applies to rentals. All of that is in Module 1. Module 2 is all about those frequently asked questions. Those questions, for example, how much should a deposit be? What happens if my tenant pays late? What happens if my landlord doesn't want to fix anything? All of those things are in Module 2. And then obviously in Module 3 is all about paperwork. So you know that our policy is everything in writing, nothing verbal. Everything has to be in writing. It makes your life so much easier. We have all the documentation there for you, from the lease agreements to the inspection forms to authorization for repair work, you name it, we've got everything for you there. You guys also know that we are currently changing the Century 21 Training Academy to Century 21 University, and with that the rental training will obviously be revamped and redone with new rental documentation. Okay, so just bear that in mind as well. All right, let's jump to questions and answers. So the first question we have for you guys is from Enzo, and Enzo is from the Western Seaboard office. He says, if in special clause of the offer to purchase, it says the property will be vacant on registration, then can the conveyancer withhold the payment to the seller of the sale?
So that's exactly what we're trying to go for. So remember, conveyancer does carry a duty to the seller, but there's case law that also says that they also carry a duty to the purchaser, right? So as a conveyancer, it's not up to the conveyancer very often to make up their mind on what to do, but a lot of conveyancers will, because they get the mandate from the seller, they see the problem and they say, well, you haven't performed. So the seller hasn't performed. The seller has not provided vacant occupation. Now the purchaser can make an issue and tell the conveyancer, I want to make sure that I've got enough money now to be able to attend to this eviction. And as soon as that dispute is raised, it starts becoming an issue on whether the seller should actually get their money or not. And more often than not, you're going to find that the conveyancers will withhold, because now there's been a breach and now there's an issue. And the only way to resolve this issue is to withhold the funds and make sure that the seller can't actually appropriate or utilize the funds until the eviction is sorted out. We normally see a lot of this being dealt with just before the transfer process takes place, which is ideal because at least then you've got a lot of leverage to say, I'm not going to allow the transfer process to take place until this problem has been resolved. But if it so happens the transfer takes place and the people didn't realize that there was an lawful occupier there and that there has to be an eviction, very quickly the conveyancer would, under normal circumstances, withhold the money. But like I said, it depends It depends how the purchaser actually approaches it. So there is a way of laying claim to that money and putting the conveyancer under a level of pressure to withhold pending the eviction. I hope that answers, yeah.
Perfect. The next question is from Amanda, also from the Western Seaboard office. Says, what if a purchaser buys a property with a lease in place and wants to change the terms of the lease from an unmanaged lease to a managed lease, but we must draw up a new agreement with the new owner?
Okay. So a purchaser buys a property with a lease in place. So they've bought it, there's a tenant and there's an existing lease, and they've taken over as landlord. But now they want the lease to be managed as opposed to unmanaged. So as long as, so remember the management component of a lease normally carries the a commission portion of it. So we would charge a rental of 6,500 Rand a month, and as leasing agents, you'd be entitled to X percentage of that, let's say 10% of that. I don't think it's necessary to draft a new lease agreement, provided that the relationship between the seller and the new purchaser, the new purchaser and the tenant hasn't changed from what the tenant had with the previous, with the seller or the previous landlord. So because the relationship with the respective landlords is identical for the tenant, the fact that now, instead of dealing with you directly, you want to appoint an agent is really the purchaser's own responsibility. So now the purchaser can say the money needs to be paid into that account. That can be a quick addendum. And whatever they take off the money as commission is between us and them. But the terms of the agreement aren't changing. The periods aren't changing. We don't even need to change the agreement altogether. All we need to do is change where the money actually gets paid into. I think that's the simple answer.
Okay, so an addendum of where the money goes to and who they should contact, because on a management lease, they'll obviously need to contact the agent instead of the buyer.
And since the agent is the owner's agent, the reality is that you can at any point appoint an agent and tell the lessee that this is a new person that you need to contact. So most of the lease agreements even allow you to do this by way of a simple letter or an email. So I wouldn't worry too much about a brand new lease. An addendum is probably the safest bet.
Right. So a question from Lizette. Lizette is from the Hoedspruit office. She says, once a lease expires and now the owner wants to take over the lease and rent to the tenant directly, how do you proceed? So it's a management lease, new owner takes over, but the new owner says, sorry, I'm keeping the tenant, agents needs to go.
So it depends on the terms of the mandate between the agency and the owner. And it does come down to contracts and how the mandates are actually being drafted, which is very crucial because I've seen two variations to this type of answer. And also remember, as leasing agents, you guys earn commission on two different things. You earn it on the management component and the procurement component. If you've charged commission for procurement, right, and you've done your job, you've procured the tenant, anyone can manage the lease after that point. The management fee is a fee. So provided that you're managing the lease, you get to charge a fee. If your mandate is terminated and it's not fixed to a specific period of time and it's terminated and you're no longer managing, then you can't charge a fee because you're not doing the job that you were hired to do. So divide between procurement and management. Where I find complications arise is when the mandate kind of it basically includes both, and there's a specific fee for both procurement and management, and this does create complications. So most agencies divide the two up. If these are basically brought together, one would probably need to do an assessment on what would be a reasonable procurement fee, whether that's being earned and paid, and together with a reasonable management fee, because at a certain point in time, yes, the owner would be entitled to exit the management agreement if they no longer want it managed. But if the mandate has a fixed period for management, then no, they can't. So it really depends on what the mandate says.
Okay, perfect. So what a lot of offices also do is, as a bit of a benefit to their landlords, if you let me manage it, I'm not going to charge you a procurement fee. I'm then only going to manage it. So now what a landlord does, I'm managing it for 2 months, but I've also procured it for you. Now you go, sorry, leave. is that tenant still the company's tenant? Or is that again going back to how that mandate was structured in the beginning?
My suggestion, so what I've done for a couple of agencies, is fix your mandate then. If you're going to give a discount, make the discount subject to management for a minimum period of time, failing which a fee will be charged. So yes, it does come down to the wording of the mandate that is crucial, because if you say, I charge nothing for procurement, but I'm charging whatever, 10% for management on a month-to-month basis, then unfortunately, contractually, you've misnegotiated on your benefit, because you're losing out. Then you need to say, I won't charge you provided I get your work for the next year, failing which you're welcome to cancel, but then that procurement charge comes back in full.
Right. Okay, so we only have 5 minutes left, so we only have time for 2 more questions. So I'm going to take Lauren's questions and Jerry's question. So let's look at Lauren's question. Lauren is from the Southern Suburb Office. She says, if the property is sold with a managed lease in place, is the new purchaser required to continue on paying the commission to the rental agent? Alternatively, can the rental agent claim the balance of the commission from the seller?
Okay. So if a property is sold with managed lease in place, is the new purchaser required to continue on paying the commission to the rental agent? Strictly speaking, not, because remember, the new purchaser doesn't have a mandate with the agent. Hier gaat voorkoop applies between the owner and the tenant. So the mandate in itself doesn't actually transfer from one owner to the other. So here, from a leasing agent's perspective, the question is, do I have recourse against the previous owner for any outstanding commission that might be due? So again, this goes back to the wording of the mandate. If your mandate bulks up the commission, so now there's a balance. So let's say it's a fixed period and you're like, you have to stay with me for a year and I charge you 10% per month for the full year. If you cancel before the full year is up, I still get X amount. So it's 10% per month for 12 months. You owe me whatever, mid-year, 6 months of commission. My argument there, and this is where the due diligence comes in. Number one, the person buying the property, there needs to be disclosure by the seller that there is a mandate and that the seller doesn't want to take responsibility for that commission that might be outstanding. So will the purchaser take responsibility? Since it doesn't pass as a matter of law automatically, you might then want to have the conversation of the sale, for example, is subject to the signature of a mandate by the purchaser to make sure that the purchaser, now there's a direct link between you as an agent and the purchaser, and you can claim money from them. If, like it happens so often, no one pays attention to the details, the sale goes through, everyone assumes everything's okay, and now the purchaser goes, well, I don't want to use an agent, it's not my problem, I don't need to use an agent. My argument there would be, you probably need to go to the original owner, because your nexus is with that owner, and try and collect the commission from him.
Right. So last question, just before I do the last question, there is another 2 questions after that. Would you mind staying 5 minutes later so that we can just answer Benita and Oki's question for them before they jump off? Would you be okay with that, Bruno?
Perfectly fine. Very happy.
Right, perfect. So the rest of you guys, you're more than welcome to jump off, but if you want to stay, that's even better. So Jerry, the Rustenburg office, he says, what happens when a person has done an agreement with the owner to the lease for 2 years with the option to purchase, but after 3 months cancels and also doesn't want to vacate the property?
2 years of option to purchase, but after 3 months cancelled. Person has done an agreement with the owner. All right, so the tenant has done an agreement with the owner. It's a 2-year lease agreement. It's got a separate option to purchase. So what we need to understand from our law is an option to purchase is technically a separate agreement. So it can be included in the same lease, but it is 2 separate concepts. And unless the wording of the contracts tie them into each other, one is exercisable several from the other, meaning that you can have your 2-year lease, and if you don't exercise the option to purchase, oh well. So that's how I'm understanding. So a tenant enters into an agreement with the owner. 2 years, and there's an extra option. So extra option, it's tenant's call whether he wants to purchase or not. After 3 months, cancelled, and also doesn't want to vacate. So he didn't exercise the option. There's no obligation on him to exercise the option. That's why it's called an option. So forget the option. It's basically, it's got no consequence on this question. Now we're talking about cancellation. He cancelled early and doesn't want to vacate. Now, as we saw before, in terms of the CPA, is allowed to cancel on 20 business days notice. So provided he gave the requisite notice, he is entitled to cancel, but then there's a reasonable cancellation fee that can be levied. So that's something that can be deducted from the deposit, and he can be sued for it. And obviously doesn't want to vacate. I mean, that's like Alexa mentioned, we've got the process. We need to manage the person. We need to give the requisite notice, and we might need to issue an eviction application if the need arises.
Brilliant. So Oki is from the George office, and he says, I assume that a landlord can give notice to a tenant if there is a clause in place where it makes provision for such notice. I referred to your clause earlier that a tenant can give 2 months notice, but the landlord does not have the same right. Or does this only apply in terms of the CPA where no notice period is stipulated?
Yes. So absolutely. So the first thing is the tenant can give 20 business days notice, not 2 months notice. 20 business days, you can terminate the lease, but will be subject to a reasonable cancellation fee. The conversations we're having here are, yes, terms that aren't necessarily specified in the CPA. But if your agreement of lease does allow for a landlord to cancel under certain circumstances within a reasonable period of time. So say, for example, you enter into a one-year lease, but after 6 months, you say it's a month-to-month lease. Effectively, it doesn't make a difference to anyone because you enter into a 6-month lease that turns into a month-to-month lease after the fact. That's not unlawful. That is allowed. So what we find from a fairness component is anything under 30 days is a no-no. There's nothing specifically that says the lease can't be for under 30 days, but then you start leaning towards short-term rentals like your Airbnbs, and it's not something that you find very often. So you are allowed in the lease agreement to make provision for some form of cancellation on a proper notice period as a landlord. There's absolutely nothing wrong with that. What you do typically tend to find is that the tenant needs to have very similar rights. So unless you can justify, for example, with construction, or you can justify it as you're selling the property and now you have to give notice. So those are allowable, and you can give notice on those specific items without the tenant having the same right. If it comes to you being able to do it on a 30-day notice period, the tenant would also have to have that same right for the sake of fairness.
So last question is from Benita, and Benita is from the Montana and the Moot office. She says, good day. Thank you so much for the information. Very helpful. I currently have a situation where we are leasing out a newly built development unit. The property is being leased out until the unit is registered from the developer's name to the new purchaser's name. When our agent conducted the exit inspection, the stove was scratched by steel wool. The developer insisted on a new stove, but is that not seen as fair wear and tear, or is the tenant responsible for the new stove?
Oh, wow. That's actually a really good question. So I suppose we need to break this down into different components. Otherwise, there might be a level of like overlap or, a fairness issue. So the property developer has sold a property to a purchaser, and the property needs to appear a certain way, right? It's a newly built property, so there is an expectation that it is relatively new. So unless the purchaser was aware that people were renting out this property, there was a lease in place, and that they don't expect the property brand new because it is secondhand. So that's actually a very, very good question, because when you buy a house that's been built 10 years ago, there's a level of expectation that there will be whatever cracked brick here and there or something. It won't be 100% perfect, but if you're buying a new build and you bought from the developer, and maybe you bought it off plan and everything got built and you picked the fixtures, then there might be a problem for the developer because he just made a promise now he can't keep because he's just made the place secondhand. And unless he brings it back to the standard that's expected by the purchaser, the developer might land up being liable. So now between the developer, in this instance, a landlord developer, and the person staying on the property, fair wear and tear is a fact. Now we take away the fact that this property's been sold to anyone else, completely separate that or distinguish that, and go, there was a landlord, which is the developer, but he happens to be the owner. It doesn't matter what he's doing with the property. Maybe he's the developer that kept the property. It doesn't matter. He's the landlord. There's a tenant. What's the relationship between the two of them? What does the contract say? Fair wear and tear. So now I can't comment, for example, on what scratched is. So there is fair wear and tear, but I mean, you know, to a certain degree, you don't want to get your stove back with proper scratches on the stove. That's, you know, that's a bit much. So that's a different question. That's a factual question. What is fair wear and tear? But I totally agree with you. Fair wear and tear would be accepted. The extent of fair wear and tear would depend on, in this instance, how bad the scratches are.
All right. Brilliant. Thank you so much. Thank you, Bruno, Leonora, Alexa. Absolutely amazing. Guys, if you have any questions to Bruno, Bruno, I think that slide's still up. There's these details. You are more than welcome to contact him with any of the things that you need to do. Scan the QR code. For those of you who don't know how it works, you simply open up your phone, go to your camera, and then just simply hover over the QR code. If you're on an iPhone, a little link will come up. You just click on it and it will take you to where you need to go. So thank you very much again. Thank you for you guys. Thank you for all the agents that joined us today. We really appreciate it. And then on the 8th of June, Bruno and the team will be back with us where we're going to chat about investors. So keep a lookout. We will send out the invites closer to the time, but they will be back with us in about 2 months' time. Again, thank you so much, Bruno and team. We really enjoyed it. Have an amazing day, everybody.
Well, thanks for having us.
Bye, everyone.
Bye.